Before we jump into the courtroom footage, let's set the stage for what might be one of the most frustrating, yet fascinating, hearings you'll see today. This case involves J.C. Owens, a defendant accused of larceny after allegedly attempting to walk out of a Walmart with around $250 worth of merchandise. On the surface, that might sound like a fairly routine retail theft case. But what makes this hearing explode into drama is the way the defendant responds when the judge asks the most basic legal question in a plea hearing: what exactly did you do that makes you guilty? In criminal court, pleading guilty isn't as simple as just saying the word guilty. The judge must establish what's called a factual basis, meaning the defendant has to clearly admit to actions that legally qualify as the crime charged. Without that, the judge cannot accept the plea, even if both lawyers agree to it. And in this case, that simple requirement turns into a back and forth that quickly tests the patience of a very no-nonsense judge. What you're about to see is a textbook example of how dodging responsibility inside a courtroom rarely goes well. The judge pushes for clear answers, the defendant struggles to admit what actually happened, and the entire hearing spirals toward a potential jury trial over something that could have been resolved in minutes. So the big question for you watching right now is this: is the judge being too harsh, or is the defendant digging herself deeper by refusing to clearly admit what happened? Let's watch how this unfolds.
So these are the people versus J.C. Owens. Can I get your appearance?
Yes, thank you, Judge. Andrew Mickus on behalf of Ms. Owens, P76268. Ms. Owens would waive any objections to appearing via video today as well, Your Honor.
Okay. All right, did you speak with Mr. Zick this morning?
I did, yes, Your Honor. I think we've reached a mutually agreeable resolution to the matter. Ms. Owens is going to be entering a plea of guilty to one of the matters, and the court will be dismissing, and Mr. Zick will be dismissing the other matter. We didn't get specifics as to case numbers, but they are essentially identical. She would agree to any restitution amount. He did not have a figure before him. I estimate that that figure is going to be 0, because I believe all of the items were recovered in both cases at the time of the arrest. So I do anticipate that. But in the chance that I'm wrong and there is restitution, she is able to pay that today.
Are you pleading guilty of your own free will?
Yes, ma'am.
And Mr. Zick, I see you're back on this. Is there a preference for the people on which matter she should plea on?
No
I'm
preference.
just gonna plead. Okay, all right. So ma'am, back on, how do you plead to the charge of larceny?
Guilty.
Were you in the city of Taylor on January 31st of 2023?
Yes, ma'am.
And when you were in the city, did you go to Walmart?
I did, Your Honor.
And when you were at Walmart, ma'am, did you take some merchandise that wasn't yours?
Yes, sir.
Your Honor, I think she's stalling just because there was an attempt to do so, but because she didn't leave with the items. I did discuss with her the legal nuances between those, and that there really isn't one. So, JC, do you understand the question? She's asking if you attempted to take any items for sale.
Attempted, yeah.
All right. Where was she stopped? Parking lot, or as she was exiting the building?
Before exiting the building.
Or as you walking out of the building, Miss Owens?
I was going towards the door.
I think she had just left the self-checkout area and was heading towards the door when store security stopped her and initiated.
And were there items that you didn't pay for when you went through self-checkout?
I mean, I don't know how to answer that. Honestly, Your Honor, I left the cart. I walked away from it. I don't know how to. And then the other one was,
Hang on, JC.
Wait, so Miss Owens, did you put property in your cart or in a bag that you didn't intend on paying for?
I mean, no, but
All right,
Yes,
I can't
ma'am.
accept the plea, then we'll get a jury trial date.
Your Honor, I'm guilty.
Your Honor, if
No,
I,
you're not guilty. Miss Owens, you've been through
I
this
just-
before. You've got
Yeah,
a ton of
I'm-
larceny convictions, right?
I'm
This isn't your
confused
first
on which.
rodeo. And ma'am, you're not required to enter a plea of guilty. But if you think you're
No.
gonna sit here, I'm talking. If you think you're gonna sit here and tell me that you didn't do anything wrong and think I'm gonna accept your plea, you're sadly mistaken. I'm happy to have
I'm
a jury
confused.
trial. I like nothing more than a
I'm-
jury trial. You either want to accept a plea or you don't, and you're either going to be honest to this court and accept responsibility or you're not. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Are we clear, Miss Owens?
Yes, Your Honor.
Let's pause here for a second because what just happened is actually a really important legal moment that a lot of people misunderstand about the court system. When someone enters a guilty plea, the judge cannot simply accept it automatically. The court must establish something called a factual basis for the plea. In plain English, that means the defendant has to clearly explain what they did that satisfies the legal elements of the crime. Without that explanation, the plea could later be challenged on appeal. That's exactly why the judge keeps pressing Ms. Owens to explain her actions. Simply saying, "I'm guilty," isn't enough. The court needs a clear record showing that she intended to take property without paying for it, which is a key element of larceny. But notice the tension building here. The defendant keeps giving answers that sound more like excuses or confusion rather than a straightforward admission. And from the judge's perspective, that raises a huge red flag. If the defendant isn't actually admitting the crime, then accepting the plea would be improper. So now the hearing reaches a crossroads. Either the defendant clearly explains what she did, or the judge will send the entire case to a full jury trial. And honestly, here's the question for you watching. If you were the judge, would you accept this plea, or send it straight to trial? Let's see what happens next.
So what do you think you did, Miss Owens, that makes you guilty of larceny?
Your Honor, the first offense, I didn't scan an item, and honestly, it wasn't to steal the item. I tried to pay for the item.
All
But
right,
it
so
doesn't,
that's a not guilty plea. So, okay, we're gonna just go ahead and set these both for
but the
jury
second
trial.
one, I did intend to. So, I mean, yes, I'm guilty on the second, yes.
You accidentally didn't scan
No.
$250 worth of items?
No, I didn't say accidentally. There was a computer or something
No,
wrong
on
with
the
that
first
scanner.
case, the allegation is that you stole 8 items worth $250. And you're telling me that was an accident?
Your Honor, I'm guilty.
Alright, this is where things get really interesting from a courtroom strategy standpoint. What you just saw is the judge essentially giving the defense attorney one last chance to straighten things out. Instead of immediately locking the case into a jury trial, the judge allows the attorney to step aside and speak privately with his client. That's actually a fairly common move in court when a judge believes a defendant doesn't fully understand what they're doing. From the judge's perspective, the issue here isn't necessarily the crime itself, it's the lack of a clear admission. Without that admission, the plea deal collapses. And if that happens, both sides would have to prepare for a jury trial, which means more time, more resources, and potentially a harsher outcome for the defendant. So the lawyer now has a very delicate job. He needs to explain to his client exactly what the judge is asking for and why giving a clear factual statement is necessary. The big question now becomes: will the defendant finally accept responsibility, or will this spiral right back into courtroom chaos? Let's watch what happens when they return to the record.
We're going to jury trial.
Your
I'll
Honor,
set
if
a
I,
jury trial date and we'll see you on that date.
There was
Your
a-
Honor, if I may have an opportunity briefly in a breakout room with my
No,
client.
I've had enough of your client, quite frankly, and the games
Ma'am.
she likes to play. She's lucky I
This
didn't
isn't
revoke
a
her
game.
bond the first time, and now she
Ma'am.
wants to play with whether or not she's responsible of this or not. And no, I'm
I'm
not
not.
comfortable taking a plea. She's made it clear she didn't do anything. We're all set. You'll get your
I
jury
didn't
trial
say
date in the
that.
mail. We're all
I
set,
did not
ma'am.
say
I'll
that.
see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail.
I didn't.
Mr. Mikos, I'm sorry, I'm not tolerating your client and her nonsense. We'll set it for jury trial. If you talk her into taking a plea that she can reasonably put on the record without being full of nonsense, I'll consider it. But for now, we're going to trial.
A few moments later.
All right, we're back on the record. This is the People versus J.C. Owens.
Yes, thank you again, Judge Andrew Mickus, P76268 on behalf of Ms. Owens.
Ms. Owens, tell me your name.
J.C. Owens.
Ms. Owens, did we go over your constitutional rights a minute ago? Do you remember those rights?
Yes, ma'am.
Knowing all of that, how do you plead the larceny?
I plead guilty, Your Honor.
Back on January 31st of 2023, Ms. Owens, were you in the city of Taylor?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
I want you to tell me what you did that makes you guilty of larceny.
I intended to steal items, Your Honor, without paying for them.
What items?
I think, I honestly, I don't remember what items exactly, Your Honor. I think they were just normal, like condoms and stuff.
Toiletries or-
Toiletries, yeah.
Did you take them with the intent to deprive that Walmart of their property?
Yes, Your Honor.
And did you take those items and put them in a bag without scanning them at self-checkout?
Yes, Your Honor.
Oh, that was amazing. Well done. That's the best turd I've ever seen. Congratulations. You're special.
Are you satisfied, counsel?
I am satisfied, yes, Your Honor.
All right. I'm going to accept the plea as knowing and voluntarily given. The case ending in 230962. That case will be dismissed per the plea.
You see, Karen, it wasn't that hard to take responsibility for your actions, now was it?
Meet with the probation department for a pre-sentence investigation. You're going to get notice of that in the mail.
Okay.
And you're going to meet with them. And I'm sorry, Mr. Mikos.
No, go ahead, Judge. I'm sorry.
Yeah, I think we need an evaluation. So you're gonna meet with the probation department, Ms. Owens, and they're gonna contact you for a pre-sentence interview. After that interview, we'll meet again for sentencing. Are you still on felony probation?
JC, are you still on probation with Judge Matthews? Yes.
Yeah.
Okay. All right. Well, I'm assuming a lot of things will likely run concurrent, but I want my probation department to at least look at it. And Mr. Mikos, I can't give you a sentencing date because I don't know how backed up they are on their PSIs.
I understand.
So it'll be a Wednesday and we'll get it out to you in the mail as soon as they meet with her.
Okay, we're probably talking a few weeks out.
At least, I think generally 3 to 4.
Okay.
And bond conditions will just continue until that time.
Sounds good. Thank you, Judge, and thank you for your patience today.
All right, I'll see everyone at sentencing. We're all set.
And there you have it, a courtroom exchange that perfectly illustrates how the legal system depends on clarity, accountability, and procedure. In the end, Ms. Owens finally provided a clear factual statement admitting that she intended to take items from Walmart without paying for them, which allowed the judge to legally accept the guilty plea. Once that happened, the court moved the case forward to the pre-sentence investigation stage, where the probation department will evaluate her background and recommend an appropriate sentence. But there's another important factor here: the defendant was already on felony probation at the time of this incident. That means this case could potentially trigger a probation violation, which might carry additional consequences depending on how the probation court decides to handle it. What stands out most in this hearing is the judge's insistence on following the law exactly as written. Even though the lawyers had a plea agreement ready, the judge refused to accept it until the defendant clearly admitted the conduct that made her guilty. That might seem strict, but in reality it protects both the integrity of the court and the defendant's legal rights. Now we want to hear from you. Do you think the judge handled this situation correctly? Or do you think the hearing became more confrontational than it needed to be? Let us know your thoughts in the comments below. And if you found this case as shocking and fascinating as we did, make sure to hit that like button, share this video with someone who loves courtroom drama, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this one. Thanks for watching, and we'll see you in the next case.